Tom Malone.
Hi, Mr. Malone. This is Christian Chorba calling from the Vermont Supreme Court.
Hello.
Hello? Can you hear me?
Yes, I can hear you.
Okay, my name is Christian Chorba. I'm a clerk at the Vermont Supreme Court calling for the hearing. Can you hear me all right?
I can hear you fine, Christian.
You can hear perfectly fine?
Yes, I can.
Okay. Well, we're gonna get started with the hearing pretty soon. You'll have 15 minutes. You're the appellant, of course, so you'll be going first. Do you have any questions?
Can you hear me okay?
Yeah, we can hear you just fine.
Okay, thank you.
Okay. You just stay on for a minute. We'll be getting started soon.
Sure.
Mr. Malone, so you can reserve time for rebuttal, so whenever you finish during those 15 minutes, I'll keep track of that, and then you can use the remaining time after the appellees have spoken.
Okay, thank you.
Okay, great. Good morning, Your Honors. The matters before the court this morning are the cases entitled In Re Petition of GMPSolar-Richmond, LLC for a Certificate of Public Good et al. Docket numbers 2016-034 and 2016-148. Representing the appellants, Alco Renewable Energy Limited, is Thomas Malone, and he is appearing by telephone. Representing the appellee, GMPSolar-Richmond, LLC, is Jeff Ham. Seated at council table with Attorney Ham is Victoria Westgate and Jeff Commons.
Thank you very much. Good morning, Mr. Malone.
Good morning, Your Honor.
Yes, I'm Paul Reiber. I'm the Chief Justice. I'm going to ask Christian Chorba, who is keeping time for us here this morning, to interrupt your argument to tell you when you have 5 minutes remaining on your 15-minute allocation and 2 minutes remaining. Okay?
Yes, thank you, Your Honor.
All right, so please go ahead with your argument.
Good morning, and may it please the court. I'm Tom Malone on behalf of Alco Renewable Energy Limited. I'd first like to thank the court for allowing me to appear by phone. Second, I'd like to update the court on the status of 2 cases that were notified in the notice of additional authority. One case has been appealed to the Second Circuit Court of Appeals. In the Massachusetts case, we have filed a motion for reconsideration of the court's order that there is no direct claim against the utility, which is one of the issues on which also based its petition to intervene before the Public Service Board as briefed in the 034 docket here.
Mr. Malone, this is Justice Scoglin. I'm sorry, I've just forgotten. Your second motion to intervene, has the board ruled on that yet? In this case?
Yes, Your Honor.
Okay, thank you. I just couldn't remember. Thank you.
Yes, that is the subject of the 148 docket.
Can I ask, this is Justice Dooley, we did get your notice of additional authority, and you've just indicated with respect to the Massachusetts case what your position is, but if the Massachusetts case comes out to be right, Doesn't it undercut your claim to the right to intervene?
It certainly does to the extent we were relying on a directly enforceable right against GMP, yes.
Right. So that gets now to the substance. If you have no directly enforceable right against GMP, does that mean you can't intervene?
No, I don't believe so, because our claim for intervention was not solely on that basis.
But it seems to be, and this is the way you started your appellant's brief in the first case, it seemed to be the center of it, which is to say that PURPA provides a direct right between you and the utility, here GMP, and all you're trying to do is enforce that direct right here, which you have been denied.
You are correct. That was the focus of the first brief.
So then your right to intervene will rely on what you had in the second brief, which is the tax issue with respect to GMP.
Well, I think, at least the way I view our status as far as the right to intervene from a state law perspective is that we are both a ratepayer and a competitive supplier to GMP. So while the direct right under PURPA does relate to being a competitive supplier, that's not the only basis on which we have petitioned to intervene as a competitive supplier. That goes to, I guess, the main point in the second brief, which is the 240B6 criteria and GMP trying to build projects on its own that do have an effect on the competitive landscape. So if an Massachusetts case is upheld, I think that clearly does eliminate one of the bases, but doesn't, at least in my view, eliminate the main state law issue, which is when should a ratepayer or competitive supplier to GMP be allowed to intervene when GMP seeks permission to build a project for its own account.
This is Justice Robinson. I'm trying to figure out, I understand your interest involves the impact on your ability to both directly contract with the utility, but also the price at which that would happen. You don't, am I correct that you don't have in the pipeline a proposal to purchase Tivepi that would be impacted, with respect to which you're standing in the line, would be impacted by the award of this certificate of public good and the presumed purchase of the power that would flow from that? Your interest is a hypothetical project. You don't have a specific application pending. Is that right?
We do not have a specific project that we propose to DEPI. I mean, projects that we have proposed or proposed directly to GMP and
Right.
the alternative to DEPI.
Following up on that, if we were to hold you could intervene under your first application to intervene, would we necessarily have to say that at least as a mandatory procedure, that the procedure that the board established in setting up DEPI is invalid? That is, can't be mandatory.
I don't think that that's the issue that the court needs to decide to allow us to intervene under the first petition to intervene.
Okay, then you'll have to explain to me why, because it seems to me me, as I go back and forth between the briefing, that the fact that the board did not, when it established its rules as how you go forward with this, allow the right to go directly to the utility in the area served, here, Green Mountain Power, and demand a contract with them, enforceable right, is central to the situation under which you're claiming the right to intervene. And indeed, it was the answer you gave me with respect to the Mass decision.
Well, if we assume that the Massachusetts decision is upheld and there's no direct right against GMP, one of the other effects on us and any competitive supplier, which we discussed and the board did reject, at least in this case, but not discussed in some of the other intervention petitions, is the effect that it has on avoiding costs. Getting a little bit farther afield, I guess, but one of the bases we said was that a PNP, based on its own testimony in the docket, if they're allowed to build these facilities, then what that does is reduce what a qualifying facility would be able to obtain either from BEPI or from GMP in the future.
The board, as I understand it, the board answered that by saying that because the rule sets a voided cost not with respect to GMP, but with respect to all the utilities in Vermont, and not based upon specifics so much of them, but this rate that it gets regionally, that the actual effect of this decision would be insignificant with respect to the avoided cost calculation under Rule 4.100. Was that wrong?
No, Your Honor, that is correct. Set a composite rate, and GMP is about 77% of that composite rate. And what would occur is what's actually occurring now, is the board is resetting the rates based upon new projections. Those would include the fact that GMP now has these distributed energy projects. So the rate, it will have some effect as GMP testifies for other small facilities like ours, even if there's no direct obligation. I think the clearer basis.
So let me try to follow up so I understand that better. Let's say the issue is whether GMP will buy power not from a renewable project, but from, let's say, more hydropower or some other place. And the rate will be low enough so that the avoided cost will reduce from that. Would you believe you had the ability to intervene on that question of whether that power purchase should be authorized because it will affect the avoided cost?
And you have 5 minutes remaining.
Yes.
Did you hear that, Mr. Malone?
5 minutes remaining.
Yes.
All right.
Okay,
Yes,
so,
you're the 5 minutes.
okay, so
If,
did you hear my question?
Yeah, I did, Your Honor. I do think we would be entitled to intervene on that basis because it does have an effect on our potential projects.
So you would intervene on the basis that the rate is too low and the board should deny that purchase because it's too cheap?
Well, I guess we wouldn't deny it, or we wouldn't intervene on the basis of the specific rate itself, just that regardless of what the rate is, reject them. So all we're asking to do is present our case. And we would intervene on the basis that whether the rate's high or low, it still produces the market size, the need that's in the gas in the future.
If we were to accept your argument, I'm trying to figure out the limits. I could imagine one scenario, right, where you have the list of applications to that being maybe you're fourth in line and number 3 in line is going to use up all the capacity for that year, and so that creates an interest in challenging flaws in number 3. But it sounds like you're making a slightly broader claim, which is that you're not actually in line, but you might be. And if that's the argument, how is it that anybody who thinks they might want to develop a renewable, a solar project, doesn't then have standing?
2 minutes remaining.
Thank you. Yeah, I wouldn't say that anybody that might want to develop a renewable energy project has standing. We are clearly a market participant. We have projects up and running in Vermont. We have been successful in the speed auction, including the most recent one. So I view this as being concrete in the sense that we are an actual market participant. We have projects. In these particular cases, we have presented the projects to GMP. So it's not so broad as to say that anybody could do it. I think our situation provides the concreteness which is necessary to intervene in this case. So unless there are other questions, I'd like to reserve whatever
Okay.
time we have.
Thank you very much. Counsel?
Good morning, Your Honors. May it please the Court. My name is Jeff Han. I'm here today representing GMPSolar-Richmond. With me seated at the council table is Jeff Commons, representing the Department of Public Service, also an appellee here. We agreed that I'll handle the argument, but if you have any questions for the department, please available. Let me jump into it. There are in this consolidated docket, there are 3 issues pending before this Court. First, whether to overrule the board and grant ALCO's first motion to intervene. And then in the second docket, whether to allow an overrule the board and grant ALCO's second motion to intervene. And also they have collaterally appealed the CPG ruling itself in that second appeal. We believe the Court should defer to the Public Service Board on all these issues and affirm those decisions. And let me jump directly into some of the questions that have come up here, particularly with respect to this first intervention request as it relates to the PURPA interest. I think Mr. Malone has conceded that there are a number of cases out there that recognize that there is not, in the Vermont statute, there is not a direct right against a utility to seek a PURPA contract. In Vermont, the way we affect PURPA is the board under Rule 4.100 requires all QFs to go to the purchasing agent. And
So you've proposed and adopt a revamping of 4.100 to eliminate completely that one.
that's correct.
So why did you do that?
So the Public Service Board, just to be clear, I'm representing an applicant
Right.
that's owned by GMP.
Got it.
The Public Service Board has instituted a rulemaking and just adopted a new Rule 4.100. I think responding to many different comments and the best way to implement these programs, ALCO's included. They
Did
participated.
it have anything to do with the fact that it was somewhat at odds with the federal regs?
I don't believe so. I think it was a change in circumstances. PURPA is 30-plus years old. The board rules are quite old. And looking at the best way to implement that program based on all the parties' comments, including the various utilities, the board has determined going forward they're not going to utilize a purchasing agreement. But under the regime in which this case arises, under the old board rule, there's no question that ALCO needed to go to the purchasing agent. We did not do that. And just to be clear, it's not just other jurisdictions that address this issue of direct liability to the utility. This court has actually looked at that issue several times. Justice Dooley, writing several decisions in the 1990s, recognized that the purchasing agent is appropriate and that purchasing agent means there's no mandatory obligation on community employees. And that's still the law of the state, and what ALCO is asking for is for you to reverse not only the board's longstanding interpretation of this rule, but this court's acceptance of that longstanding interpretation.
Do we have to reach that issue?
You need to reach the issue, well, at the broadest level, I think you can simply defer to the board's interpretation of its own intervention rules.
Let me be more specific. If we conclude, let's pretend we conclude that there is a direct right. Is this CPG proceeding, do they have a legal right to use this CPG proceeding as a mechanism for challenging it? Because if the answer to that is no, then we maybe don't have to even address that.
Thank you, Your Honor. Yes, I think that gets directly to the question of standing. And this is another issue that's been addressed numerous times by the courts, including specifically related to ALCO. So we do question whether they have any protected right in demanding a contract from GMP or any particular avoided cost rate. So one, their position just misunderstands PURPA. PURPA does not say you may intervene in any utility action which might affect a future avoided cost rate. It simply says you as a developer, a qualified facility, have the right to request a contract, demand a contract at a certain price that's equal to the avoided cost at the time you're ready to build that facility or close to that. ALCO had this direct issue was addressed actually by the Second Circuit in 2015. We didn't cite this in our brief, so let me give you the site. It's ALCO Finance Limited v. Klee, K-L-E-E, and that's 805 F. 3rd 89. And there the court, let me just quote, says, ALCO asserts as an alternative theory of injury that it will earn a lower profit from future energy sales under PURPA because the challenged procurement will affect the utility's cost structure. For an injury to be cognizable as an injury in fact, the plaintiff must have suffered the injury at the time of the complaint's filing, or the injury must have been imminent. Neither is true here with respect to the asserted injury. PURPA sales that ALCO fears would be made at a lower price clearly did not occur at the time of the complaint, as they were future sales, and there's no indication in the record that these future sales were imminent when the complaint was filed. And as such, it's a speculative interest that can't serve as the basis for standing. I think that is consistent with this court.
Wait a minute, I haven't read the case, so obviously my mind is worried to see its relevancy to this. It isn't the CPG intervention case, I would say, from your description of it.
Correct.
So in fact here, they are in a circumstance where an approval will, they want to approve, lower their profits. I think that is not from what you just said.
Well, it's similar to the argument they're making here, that this was not a CPG proceeding, it was a statewide procurement. But ALCO was making the same argument. Essentially, they were arguing that the avoided cost might be lower. And Justice Dewey, I think that gets directly to your question to the appellant, which is, do you have a right in a particular avoided cost? And in interpreting that, we need to be cognizant of the role that a utility like GMP plays in the overall scheme here. GMP's obligation is to serve customers and to serve them by providing the lowest cost power possible.
But for a CPG, the PSB considers a lot of issues, land conservation, screening, etc. But it also considers, quote, whether the facility will avoid, reduce, or defer transmission or distribution system investments. So my question is, notwithstanding the board's decision that the rates under 4.10 are based on state composite rates, it says the construction of a 2.2 solar facility within the broader regional market would have virtually no effect on these rate projections. So you've got rate projections, but you've also got to consider transmission or distribution system investments. So if there's a QF out there that exists, why would you find a CPG in constructing a different new facility when the QF could provide the energy that would be equivalent?
Right, well, that standard is actually not one of the provisions that ALCO alleges an interest in. That's criterion B
I'm just asking.
in general.
Yeah.
I think the answer there is, first of all, PURPA is not in a direct sense an either-or scenario. GMP, as a regulated utility, has a responsibility to responsibly manage its power portfolio, and that will include purchasing power, developing projects, all to avoid unneeded expenses to ratepayers, such as investments in transmission distribution. There's not an argument that these two projects, if Alco had actually had a specific project in mind, would have an impact on this issue of distribution or
You are not, right, to what, even though we're in a renewable world here, and we've got a bunch of renewable cases, you are not actually a QF, right? You're not coming in under the rules with respect to qualifying utility for renewables.
That's correct.
Just a power purchase like any other one, hydro or a gas plant or anything.
Just to be clear, so GMPSolar-Richmond is an affiliate of GMP. It is a project that will likely ultimately be owned by GMP and its ratepayers.
But Alco's a QA.
Alco is a QF, correct, yes. And if I can just answer this question about the interest, just to go back to your question, the interest in avoiding costs. This court has also looked at this question of whether Alco is essentially arguing that it has a vested right in maintaining avoided costs at a certain rate so we can get that rate. All the while, it does not actually follow the appropriate procedure. And this court has said in a petition of the Department of Public Service in 1991 that they're not going to apply vested rights doctrine to changes in the avoided cost issue. So a developer, unless it has a legally binding obligation with the purchasing agent for a specific price, does not have a protected interest in ensuring that the avoided costs will be higher in the future so that it can obtain those. In fact, that's in direct contrast with what we want utilities to be doing, which is providing the lowest cost power possible for the ratepayers, which is the goal of GMP is the most common implement.
But aren't they saying that? I thought they were arguing they can do it at a much lower cost for ratepayers, and by getting your project into the pipeline, it's gonna impact your ability to do that.
Yeah, it's to be honest, their argument is a little bit confused. On the one hand, they say they don't want the project because it's going to make GMP's avoided costs lower. And on the other hand, they're saying it might make their costs, GMP's ratepayers' costs higher. I think what the evidence in the record actually shows is that GMP, the department, and the board considered whether this particular project was within the universe of low-cost alternatives available to the utility. And the answer from all those entities, including the board's findings, was yes, it is. But the issue, Alco's arguing, again, gets to the speculative nature of its concern. It's arguing with respect to the tax structure that it believes the tax structure of some of these deals is not appropriately structured. They believe the IRS might not allow that structure. They don't know, but they're speculating they might not allow it. Our tax experts would say different. If that happens, will the board pass through that increased cost to the ratepayers? That's uncertain. And it's uncertain whether GMP would actually bear the burden of that loss. In other words, there are contractual arrangements between GMP and its tax equity investor where the utility may not bear any of that burden anyways. So those speculative concerns just again highlight why the board was correct in drawing the line at the intervention level, saying these issues removed from the substantive criteria in Section 248 are also so speculative that we shouldn't address them.
Now, I understood in the second intervention that this issue was mentioned in the first, but then fully agreed to the second.
Yes.
I understand they're going a little further. They're saying, you court, you go read these decisions, you go read the law, and what you're going to determine is this is a house of cards that's going to fall apart, and because it's a house of cards that's going to fall apart, we can intervene in order to force this issue forward. So it's not speculation when you use. They think they made the argument that shows you can't survive any inquiry as to this.
I agree that is their position. I think that's a strange reading of what they're attempting to do. They've presented their own, essentially expert testimony through the appellant of what they think the IRS will do. It's clearly that speculative, but there's also issues of fact there that if they needed to be judged, should not be judged by this court on which instance. We don't believe there's any reason to get there, but the concept that this court could decide as a matter of law that a certain arrangement which has not been tested in detail, because it's not within the scope of this proceeding, is not appropriate.
Although I think their argument's a little softer than that. It's, we've raised enough of an issue that we ought to be able to intervene, develop it, not that they're asking us to decide on the merits.
I think that would be a generous interpretation of what they're saying. They seem to suggest as a matter of law directly in the brief that this is decided. And that, if it was the former, then I think, yes, you're in the construct of deciding, should we defer to the board, who is the expert administrative agency evaluating these issues and making judgments, as this court has recognized, having some discretion over things like intervention in order to control the docket. The board has said here is not, we're not going to give any consideration to any of these issues, simply that this 248 proceeding is not the right place.
So am I right that, let's suppose it is a house of cards and it does collapse, that there's an opportunity at the rate setting level to essentially have the producer swallow that, not pass that on to ratepayers?
Correct. And I think as DPS counsel would stand up and say, it's their responsibility as the ratepayers protector to stand up and do exactly that. The circumstances turn out to be different than what represented. And there is a different cost, and the department certainly take a position on whether that should be passed through. Excuse me.
Yeah, I'm trying to understand whether on the second intervention, you argue that the substantive, you haven't gone back to the procedural question. Do you agree that second intervention is properly here, question, by one of the rules, either by the interlocutory or the appeals of the order, or the final appeal of the CPT?
Let me give two responses to that and the explanation for why. Obviously, this court has to find that it has jurisdiction over that intervention we decided, and I think there are legitimate concerns about that, particularly as it relates to whether the first intervention motion transferred jurisdiction over intervention to this court, which I think is a correct interpretation of this court's law. If you were to find that you do have jurisdiction on those issues, then we would certainly encourage you to rule now on the substance of those points. In part, and I think the court is aware of this, there are 6 other appeals filed by Alco in related proceedings that are on waiting status to address some of these same issues. Certainly you need jurisdiction to find them, but